Imagine this. A U.S. senator confronts Kash Patel and flat out accuses him of running an enemies list. 20 people allegedly targeted already, 40 more to go. Patel denies it, but then the spotlight turns to his own grand jury testimony, and the contradictions start piling up. This clash isn't just about politics, it's about truth, power, and accountability.
Thank you, sir.
When you were here for your confirmation, we talked about your so-called enemies list. It appears to me that there have been adverse actions of various kinds taken against about 20 of the 60 people on your enemies list. You've been in office for 7 months. At that rate, you've got 14 months until you've hit all 60. Can you explain that?
Again, that is an entirely inaccurate presupposition. I do not have an enemies list. You can continue to characterize it as you wish. The only actions we take, generally speaking, for personnel at the FBI are ones based on merit and qualification and your ability to uphold your constitutional duty. You fall short, you don't work there anymore.
Well, there was a list. You don't like it to be called an enemies list, and it had about 60 names, and about 20 have had an adverse action. So those are, I think, pretty clear facts. Let me move on to your grand jury testimony, which we also talked about when you were here. I think you indicated that you understood that a witness in the grand jury is free to discuss afterwards whatever they told the grand jury. And you then went on to suggest, saying, I can't go into court orders granted by the DC District Chief Judge, and you want me to violate a court order. In those remarks, you fairly plainly suggested that there was a court order of some kind that somehow restricted or limited your ability to discuss your own testimony to that grand jury. Since then, that chief judge that you mentioned, Judge Boasberg, has written, and I'm quoting him here, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee. Can we confirm here today that there is no court order of any kind that limits your ability as a witness before the grand jury to discuss your own testimony to that grand jury?
We can confirm that pursuant to my action, that grand jury testimony has been released, the transcript.
Let's, in what forum was it released, may I ask?
Publicly.
Okay, we'll check.
When Senator Sheldon Whitehouse turned to Kash Patel and brought up the so-called enemies list, the tone in that room shifted. You could feel it. This wasn't just a policy question. It was a moral and historical challenge. Whitehouse pointed out that nearly 20 people on that list, a list Patel denies even exists, had already faced adverse actions in the short span of 7 months. He even put it into simple math. At this rate, the full 60 would be gone within 14 months. That's a devastating way to frame it, because even if Patel never wrote down the words enemies list, the pattern itself starts to resemble one. And in politics, perception can be just as powerful as fact. Now, think about why that word, enemies list, hits so hard. It's not accidental. It's a phrase burned into American memory from the Nixon years, when the White House actually compiled lists of critics and sought to weaponize the machinery of government against them. To invoke that language is to draw a direct parallel to one of the darkest chapters of abuse of power in modern political history. Whitehouse is tapping into that history to make his point sting, and whether you think it's fair or exaggerated, the association lingers. Patel's response is a flat denial. He insists there is no list, that personnel actions at the FBI are based on merit and constitutional duty. That sounds clean, procedural, official, but Whitehouse wasn't really asking for the paperwork. He was pointing to the outcomes. And this is where the deeper issue lives. In democratic institutions, patterns of decisions can erode trust even if no list ever exists on paper. People look at who gets targeted, who gets removed, who gets silenced, and from that, they infer motive. It's a reminder that governance isn't judged only by what leaders say, but by how their actions look to the outside world. Then the conversation shifted to something even more delicate, Patel's grand jury testimony. This is where a lot of viewers get lost because the rules around secrecy sound intimidating. Patel had previously implied that he couldn't discuss his testimony because of a court order. That sounds legitimate. Grand juries are secret for good reason, to protect witnesses and investigations. But here's the nuance. Those secrecy rules bind prosecutors, jurors, and court staff, not the witness themselves. The witness is free to speak about what they personally said. Judge Boasberg, the chief judge in Washington, spelled that out in black and white. He clarified that Patel was never barred from discussing his own testimony. So when Whitehouse pressed Patel directly, asking him to confirm that there was no court order, it exposed something important. Patel had leaned on the aura of secrecy to avoid answering questions, when in fact, legally, he was free to do so. That doesn't automatically mean he was lying, but it does mean his earlier suggestion was misleading, and that matters. Because every time an official blurs those lines, even subtly, it chips away at public trust in institutions. The broader lesson here is twofold. First, when powerful officials deny accusations, we have to look not only at their words, but at the patterns of their actions. Second, when legal rules are invoked in public debate, it's essential to know who they actually apply to. Too often, secrecy is used as a shield, sometimes legitimately, sometimes for convenience. But understanding those boundaries is the difference between seeing transparency or falling into the fog of misdirection. What we witnessed in that exchange wasn't just a senator pressing a nominee, it was a test of accountability. Whitehouse's job in that moment was to highlight potential misuse of power and inconsistencies in testimony. Patel's job was to defend his integrity and legitimacy. And your job, as someone watching and trying to understand, is to sift through both and ask which story holds up under scrutiny. That's why hearings like this matter. They're not just theater. They're part of the mechanism that forces people in positions of power to answer uncomfortable questions, on the record, under the lights, with history watching. Because if there really was an enemies list, that's a betrayal of democratic values. And if officials are overstating legal restrictions to avoid transparency, that too is a breach of trust. These aren't small details. They cut to the core of how power is exercised in a republic. So here's where I want to bring you in. Do you think Whitehouse was exposing something real, a pattern of retaliation, a misuse of secrecy? Or was this just another example of political theater designed to score a headline? Let me know your thoughts in the comments, because these discussions matter. And if you want to keep unpacking moments like this, the places where law, power, and politics collide, make sure you're subscribed. Because the more we understand the mechanics behind the drama, the harder it becomes for anyone to misuse them in the dark.